All right, hi again. Welcome back, Attorney Steve Andre, and welcome to another exciting episode of Litigation Whiteboard. All right, today we are talking about an important topic, whether you're in state litigation, federal litigation, or probably even in any other kind of litigation for that matter. The protective order. What is a protective order? You hear this word all the time. I'm going to be seeking a protective order. What does that mean? Well, without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, here we are. We're back. I told you guys I would be back. Thank you for your patience. I had a lot of things going on. I was preparing for 2 trials. My head deep up in paperwork, everything. But I'm back. I have a great video today on protective order, okay? So what happens, sometimes you're in a litigation and somebody says, well, I'm gonna seek your medical records. Let's say I'm gonna seek your psych records. I heard you have a psychologist. I'm gonna get your records, and you say, whoa. I'm gonna need a protective order. You're not just gonna take my medical records, my psychological records, and do whatever you want with them. Put them into the court system. On the federal cases are on Pacer online. I'm not just gonna let you take those records and post it up there and use it in a trial. I want a protective order. I want to protect myself, my name, my reputation, my family, whatever, from, here we have it here, protect from embarrassment, harassment, annoyance, oppression, undue burdens, and you may have confidential and trade secrets in a litigation like trade secret. What's a trade secret? The Colonel's secret recipe, which, by the way, I haven't liked so much. But the Colonel's secret recipe is a trade secret. So if you get into a trade secret case, they're not going to put the Colonel's secret recipe on Facebook on the federal PACER system. They're not going to do that. So this is why we have protective orders. Protective orders, okay? You can find these in the federal rules under our discovery provisions, FRCP, which stands for Federal Rules of Civil Procedure. Okay, so you're going to find those are the rules that govern you in a federal court. If you're in a state court, like California, you may have the Code of Civil Procedure. Your states will have their own rules. If you're in federal court, we're looking at the federal rules. This is what they teach you in law school. They teach you the federal rules. Okay, so you get here and you say, wow, they're trying to get my psych records. It's embarrassing, annoying. I need a protective order to protect me from the party that's trying to reveal these. Now, there's 2 ways you can do a protective order, and I have it right here. By motion or by stip. So usually between attorneys, the first thing you're going to try to say is, well, why don't we agree, or why don't we stipulate to a protective order? And the other party will say, yeah, okay, yeah. Usually they'll agree, as long as it's something reasonable and something we can agree on, okay? But you can do it by the motion if they don't. If they say, go file your motion, or we're not going to stipulate to that, go file your motion. Okay, you have, of course, usually your meet and confer obligations. I have a video on how do you file a federal court motion like a pro. Go check that out if you want to know what I'm talking about. You can file a motion. And in these motions, or even in these stipulations, what you're going to be looking for is good cause, narrowly defined terms. What are we going to do? Okay, and oftentimes that comes down to what we call a disclosing party who's going to be disclosing protected material, and a receiving party. For example, a subpoena. Say this is the plaintiff in the case, and the plaintiff says, I'm going to serve a subpoena on Facebook. Okay, let's call this Facebook. Let's left-handed. I'm going to serve a subpoena on Facebook. They're going to come up with information. And this party may say, well, you can seek that stuff, but I mean, there's stuff in there I don't want everybody to know. That has nothing to do with the case. It's embarrassing, harassing, annoying, oppressing, or causes an undue burden. So in a case like that, you say, well, I want to see what the discovery is. I want to challenge it, or I want to, more likely, I want to, not challenge, but I want to designate this as either confidential or parts of the discovery as confidential, or what we call attorney eyes only, and I'll talk about that in a second, okay? So you can reach these agreements, or you can file a motion, but basically what you're trying to do is you want to basically protect yourself and your parties and your third parties and your family members from basically the abuses of litigation. So you're protecting somebody by getting a protective order. Just keep that in your mind, okay? Big points on the bar exam, by the way. If you happen to get a fact pattern like this and boom, you're saying, you know, what would you do? I would go seek a protective order to protect them. Okay, so you can do it by motion or by stip. You need your good cause standard. Usually a judge is going to want to make sure it's a good, because for example, if you say, well, let's agree to seal all records. Let's agree to seal all the documents that we get. Let's agree to seal. Well, in court cases, there is a preference for judicial access, for the public to access judicial documents and not to have them sealed from public view. Now, if there's a good reason and you have good cause and you could say, Judge, here's why we've agreed to seal the records. You know, that's one thing, but there'll be a little balancing test. Does the public have right to access? Does it not? Should we allow you to seal records? Blah, blah, blah. Should we allow the things you're looking for in your stipulation or in your motion for a protective order? Should we grant it? Should we modify it? The courts have wide latitude in how to respond with a protective order, whether it's by motion or by stip, okay? So these need to be fair, reasonable, narrowly tailored, all that good stuff. When you get into a litigation, sometimes you'll have this clause right here, attorney eyes only. And I would encourage you highly, if you see that clause that says attorney's eyes only or counsel's eyes only, something like that, be very careful. What you're saying here is when you designate something as attorney eyes only, you're saying, I'll share it with this attorney and this attorney. We will share it and we'll look at it, but not the client. We don't want the client to see. It's something so secretive. It's private. We don't want people to see it. It's attorney eyes only. So you look at the document and you say, wow, that's incredible. And you can advise your client, but you can't show your client the document. So that can be a problem if you're needing to get experts in the case and things like that. You don't want to just go willy-nilly just agreeing to these things because they're there and you just go, oh, attorney's eyes only. Okay, we can designate things attorney eyes only. So be very careful when you see this in a protective order I have here. Be very careful. A lot of times this will apply where you have trade secrets, things like that. But be very careful. Don't just jump into that. If you need to get legal advice, get some legal advice on that before you're signing off on this. Once you stipulate, it becomes an agreement, assuming the judge approves of it. And so you need to be very careful. So other than that, it's a way to, protective orders are the way to keep things confidential or to prevent embarrassment, annoyance, harassment, those kinds of things. Maybe the judge says, well, I'll let you do the depot, but only 3 hours. You can depot the family member, but only 3 hours. Let's avoid annoyance and undo things like that. So keep in mind, this is a key tool in the litigator's toolbox. Lots of courts now, especially federal courts, have model protective orders, and they will want you to use these. So usually, like the Northern District of California, okay, federal court, you can pull up the model protective order. The courts will want you to use this. You can try to modify a little bit as long as you're doing things right here, doing it right. And there's model protective orders that can be used. So check out your court. Does your court have one? Do they like one? Do they suggest one? If not, you may have to create one. Now, for me, these are one of the most mind-boggling things in law. I don't love, candidly, I don't love doing them. You have to do them. You have to read them very closely. Sometimes they can be 10 pages long, and you got to know what's going on, who's disclosing, who's receiving, what is the process if somebody's calling everything attorney's eyes only when it really isn't. What is the process to challenge that? All that gets laid out in a protective order. And I have up here, some courts don't like these protective orders due to the risk of what we call satellite litigation. In other words, you're already here fighting one case, you're going back and forth, and then you're over here fighting about what does the protective order mean? What does the protective order say? So now you got more little sub-disputes over here about every little thing, every little designation. So you want to be careful about that, okay? But that's really it. I think, do I have anything else here? That's pretty much it. Pretty simple. It's a protective order. Now, you know more than most people do, more than your average bear, about what a protective order. Where'd you learn it? Attorney Steve's Litigation Whiteboard. Civil litigation, you can find us on the web at attorneysteve.com. Make sure you subscribe to this channel. We're going to hit 25,000 this year. 25,000. So we've been working hard for a lot of years. We thank you guys for watching so much, leaving your comments, giving us a like, and if you absolutely think it's rubbish, okay, go ahead if it makes you feel better. All right, Attorney Steve, have a great week. This is your last chance to get out there and vote. Get out there and vote. Whichever way the dice rolls, folks, we're going to be fine. We can live together. We can succeed together. We can do it. So let's all stay together, okay? Take care now.